Good afternoon. I'm Danielle Conway. You're watching Life in the Law in the ThinkTech Talk series. Today, my guest is Stuart Huang, and we're talking about intellectual property in the islands. This may seem like a topic that should not really be discussed here, but I think more and more as we advance in modern age, we need to be talking about it here in Hawaii. So Stuart is here to help me walk through the discussion of intellectual property in Hawaii. Stuart was a partner at Steptoe Johnson and then also a partner with a Wall Street firm. And you practice primarily patent law.
That's right.
Prosecution and litigation.
Yes, I did.
What did you do at the New York law firm? I forgot the name. Help me with it.
It was actually, my first law firm was a firm called Cushman, Darby and Cushman. They were a 100-year-old firm, and I began mostly helping people get patents in the patent office. But over time, I got more involved in doing litigation and enforcement, and ended up getting caught up in what was called at the time the chip wars.
The chip wars.
The chip wars. For a while, Texas Instruments, which had a very large body of patents, was protecting its domestic market by suing all of the Asian semiconductor chip makers, like Samsung and Toshiba and those guys. So I got involved first in a series of cases for Samsung, and that sort of set the tone for a lot of the rest of my career after that.
Okay, and you've done some really exciting things in your career. So then you moved from Cushman to Steptoe Johnson.
I did, that's right.
So what prompted that move? Did they woo you away for you to become a partner, or what was it?
Oh, well, it was a bit of a counterintuitive decision by a lot of people's standards. At that time period, prior to about the time I was making the move, most of the patent lawyers were in what we call boutique firms. They specialized in patents and intellectual property, and that's really kind of all they did.
Right.
And as intellectual property became more important to American companies and American competitiveness, it actually became part of a bigger trade defensive geographic market strategy. The general practice firms wanted to get in on this growing, lucrative, important practice. So the general practice firms began wooing away talent from the boutique firms, and I was kind of caught up in that movement at the time.
Well, I don't want to give away your age, but what are we talking about? Were the chip wars of Texas Instrument in your time at Cushman, was that in the 90s? And
let's see, the cases I did there would have been early 90s, 90, 91, 92. And the wars have been going on for a while. I had just popped out of law school and kind of got dropped into the meat grinder.
Fray, yeah.
But it was really a lot of fun.
Well, it's interesting that you started us there with the chip wars, because intellectual property has really transformed itself as a practice area. And you just alluded to it by saying, now it's become an issue that involves trade.
It is.
So where are we now, and what's that evolution been for intellectual property protection, intellectual property rights, and where have we come to now?
Yeah, two factors drove it, particularly in the patent area, because technology is such an important part of the American economy, but intellectual property in general, media, movies, software also are the same thing. One was the evolution of the Court of Appeals for the Federal Circuit. Before the Court of Appeals for the Federal Circuit, each other circuit had its own jurisdiction, and there was a lot of hit or miss. Some areas were pro-IP, some were anti-IP, some looked at it like a violation of antitrust. The Federal Circuit standardized the decision-making process, made it more reliable, made it more predictable, and so that was one part of it. The other was the free trade movement, the reduction of trade barriers for geographic markets. So it became less popular and almost really not proper for the United States to put up tariffs and trade barriers around the United States against foreign imports of technology. But it was acceptable for a company to defend its U.S. market by intellectual property. So intellectual property became a surrogate for geographic market protection. TI could defend the U.S. market not by saying to the federal government, put a tariff on the foreign chip makers, But by suing the foreign chip makers and saying, you are using our technology, you've stolen it, we have patents on it, you cannot use that here. And so it became something of a surrogate for trade protection.
I see. So we have more defensive protection of IP as opposed to this prospective protection. But has this shifted gears now? Are we in an era where IP is king?
IP plays a really important role for the United States in a global economy. The U.S. has a very high cost of living. Our salaries are high. Expenses here are high. But it's a global supply chain. So in America, we invent and we create. That's one of the things that we do uniquely well. We make great movies. We envision iPads. We come up with new technology. I think personally more so than most any other countries in the world. The manufacturing of that all happens somewhere else for the most part.
Right.
Because the economics drive that part of the process to lowest cost volume production. Then those products come back into the U.S. where they're sold. So the high value part of that chain is in the creation part and the sales part. The more commodity, lower margin part of that chain is the manufacturing part. Intellectual property at the beginning is one way that companies get to keep control of their products as they leave the country to be manufactured elsewhere, and a way for them to control that end price point when it comes back into the United States.
So as you're talking about this chain or this cycle, I'm beginning to see where Hawaii can fit in this cycle. We obviously here could not support a complex manufacturing base, but we definitely could support assistance in protecting IP, even IP development and price point development too, once it re-enters the United States.
I think it can. I'm relatively new to the islands, and I think other people can probably talk better than I can about the economic environment in Hawaii for technology development. But I have anecdotally bumped into quite a few people here who are developing technology, who have ideas. And Hawaii can be a little bit like America in general, in the sense that the cost of doing business here is maybe higher than in some foreign countries. And so, yeah, IP can play that same role here, to say, we can invent here, we can create here. That's the high value part of the process. So I do see people inventing, I do see people creating. They do want to protect their inventions, and so I do think there's a need here in Hawaii and for intellectual property.
So this need that you have begun to see, are we talking startups? Are we talking just new entrepreneurs who are getting started on the road to creation?
Yeah, I think so. Just again, this is anecdotal, but I've run into a number of companies and also people working in the university who are pushing out into new areas. We don't have a big Silicon Valley-like industry here. We don't have large corporations that are doing large amounts of development. We do have mostly smaller ones, but that's where the niches are. That's where there's an ability to have an industry. So yeah, they are mostly startups, early stage companies. Many of them are in the angel funding range, where either the founders are still financing it out of their savings, or they've got family and friends trying to pitch in, a little bit here, a little bit there, and it's a tough stage to be in.
It is a tough stage. You've seen, because of your practice, big companies. You've seen established companies. You've also helped startups in your previous practice.
Yes.
I guess I'm wondering, how do we size up?
Well, I have not seen a lot of big corporate stuff here. So when I was still on the mainland, so my last cases were for companies like Japan Airlines, Toshiba, Kellogg. We don't have many of those kind of companies here. I think startups are kind of the same everywhere.
Okay.
Some places maybe have a little more capital, so if you want to do an electronic startup maybe in Silicon Valley, you're going to have more of a talent pool and maybe more of a venture capital pool. Other than that, maybe in amount, I think the quality is still kind of the same. Founders live on beans and rice until they get get to revenue.
So you've had an opportunity to actually talk to a couple of founders as you describe them. And I'm happy to say that a couple of those founders are right out of our William S. Richardson School of Law.
They are. Yeah.
Yeah. What were these students coming to you for, and were they actually on target?
Yeah. Yeah. So there was a group of students, and I think they did a really great team building job.
Mm-hmm.
They had someone who was sort of out of the engineering school, and someone who's out of the business school, and someone who's out of law school. It wasn't like 3 engineers getting together or 3 lawyers getting together.
Right.
So they had a mix of talent, and they came up with an idea for a product.
Mm-hmm.
And it was an interesting idea. It was one of those things where it may not necessarily be considered, pushing the state of the art of nuclear science, but frankly, a lot of product invention is taking things that pieces that have been around and putting them together in a different way to achieve something that no one else did.
Right.
And so I think they had a really neat idea.
Mm-hmm.
They were maybe doubly poor. They were founders and students.
Right.
I mean, it's twice nothing, more nothing than
Right.
But so I got a referral from
Mm-hmm.
you actually to talk with them, and I met with them a couple times, try to explain to them how a patent and other intellectual property plays a role in the business. What is its job? Why does a company obtain intellectual property? Now it's easy, it doesn't take any time. I mean, it's not a lot of work. It's very easy to do, and they got it. I mean, they could understand that. And at some point, they wanted to get a patent on their product.
Mm-hmm.
So I tried to help them think about what they could do to move that process along without having to spend a lot of money. And at some point, you can go to the attorney, and the attorney's going to charge the fees. And for an early stage company, cash is like air.
Right.
You know, without it, you
can't
suffocate.
breathe. Yeah.
Can't breathe. So I tried to do really some basic education. I saw my role almost as an educational role more than not almost, it was more of an educational role than a service provider role. Explain them where they could get resources to educate themselves, kind of point them in the right direction, tell them what things they ought to be working on. For example, they needed to know whether their invention was new. How do you do that? One thing you do is you search for prior examples. You search the patent office records, and you can search product databases and things like that. So I kind of pointed them to where it was. I showed them how to use the tools and let them hack away at it.
Right.
And they kind of iterated a cycle, and they came back and they came up with some materials, and they had their facts. And as lawyers know, you take the facts and then you go to the next step of the analysis. So I helped them to look at how to use the information they got to make the next decision, which was, okay, is this worthwhile? If we go and we retain a lawyer, are we going to waste our money? Do we have something that we could use in our business?
Right.
It was almost a business, in fact, it was a business discussion more than it was a legal discussion. It said, okay, assuming you could get patent protection, how does that help you make profit?
So do you find that this advice you were giving them is becoming standard advice for all of the startups that you've been able to connect with, to go out and search for themselves first before?
Not actually doing the search themselves, but I think most founders, most entrepreneurs are generalists. They may have a specialty, they may have come out of the business world, they may have come out of the technology world, but they don't know everything, and they're trying to know everything. And a president or a CEO is a generalist at the end of the day.
That's right.
So, yes, I almost always, even as a practicing lawyer, would begin with the goal. And I think law can generally be treated this way. It says law is there to serve a purpose. It has a role to play in our society, or a role to play in business. And when you talk, I like to talk company talk.
Yes.
So when you go to a business person, say, I believe you should spend some of this money on a lawyer rather than another programmer, or rather than more office space. The president or the decision maker has to weigh the cost of capital. Am I going to get more for my business by giving it to this lawyer, or by giving it to this real estate company that wants to lease me bigger space, or by hiring somebody to do something in the company?
Right.
And I begin by trying to say, okay, this is why you would want to retain a lawyer to do this work. And intellectual property law is different from most other areas of law that way.
Tell me about that.
Oh, it's property. It's property. Property has a value.
Yeah.
For most companies, retaining lawyers is a cost. Okay, I have to comply with my taxes. I've got to make sure the contract doesn't do something silly. It's going to be a drain away from the net worth of the company.
Right, right.
It's an expense. Intellectual property can be that because you are going to spend money and you may or may not get something for it. But if you do get a patent, if you do get a trademark, if you are able to get a legal right that assists your business, it's a value to the company. And that value can be greater than the cost of the service. In fact, hopefully it will be. If it's not, I have a hard time telling
cost
a
benefit.
businessman to do it. But it's an easier case for patents to say, you've got different kinds of property in your business. When you go to your balance sheet and you list your assets, what are your assets? Well, you've got some computers. Oh, we've got 2 patents.
Right.
And that can be, sometimes that's the major asset of a company. I hate to say it, but I've also been with enough startups to go all the way through to what I call the end game.
Yes.
And sometimes the end game is not always an IPO or a private placement, and sometimes the founders do not walk away with millions of dollars in a private jet. But I've quite a few times seen that when you get to the end and the venture may be dissolved, the single asset, greatest asset left in that company is the intellectual property or the patents. And I've seen some companies where they've gone out and they've sold the patents as part of the liquidation process.
Right. So what you're saying is that there are securitization opportunities, either successful or in the dissolution of the business. But also what you're saying is, and I want you to elaborate on this, there may be a new model, a new business model for the lawyer who represents clients with potential intellectual property rights. There may be a new model in helping those clients.
There are. That's another way that intellectual property law differs a little bit from other law. One model that has come up, which is very controversial, and many people would say it's not necessarily a good thing that this model developed, is what are called the non-practicing patent owners. They're companies that will go out and buy and acquire patent rights from other companies that may not be using them, and monetize those patents by demanding royalties and enforcing and suing. We sometimes call them the patent trolls.
The trolls.
The trolls. I don't like the word, although I do know some and have defended against some of them.
Yeah.
I think each of them has their own role to play, and some of them, maybe more than others, have policies where I think they do play a valuable role in the commercial sector.
Well, let's take a break. When we come back from a break, can we talk a little bit more about what these trolls are doing for the market, and whether what they're doing is a service or a disservice for
Be happy to.
the economy. I'm Danielle Conway. You're watching Life in the Law in the ThinkTech Talk series. We'll be back in a minute.
I'm Hong Jiang, host for Asia in Review on Tuesdays.
And I'm David Day, host for Asian Review on Thursdays. Both of us broadcast our respective shows at 4 p.m.
And my topics tend to deal with questions related to environment, culture, history, and sometimes human rights.
And my shows tend to be on international business, foreign policy, geopolitics, and national security. And you can watch our shows live on the ThinkTech website at thinktechhawaii.com.
And you can also watch us on YouTube or Olalo.
So come join us on Thursdays at 4 p.m. I'm David Day.
And on Tuesdays at 4 p.m., I'm Hong Jiang.
Aloha.
Aloha.
Welcome back. I'm Danielle Conway. You're watching Life in the Law. My guest here is Stuart Huang. He is a patent attorney, both prosecutor and litigator, also a teacher, and we'll get into that. But right now we're talking patent trolls.
Patent trolls.
This has been big in the news. Now, are all patent trolls bad?
No, I do not think that all patent trolls are bad, but I do think that some of them are not really contributing to the net value of our economy and our society. So it's a little bit like arbitrage in the securities markets. There are people who get patents, they have great ideas, they have legitimate intellectual property, but turning that patent into royalty income is beyond their capability, either because of resources or experience. And frankly, there are people who will go out and just steal and take a technology without trying to pay for it. They can be bullies who basically say, what are you going to do about it? So in those circumstances, there are organizations that bring in financing and expertise in licensing and enforcement to help that patent owner stand up to the big guys and stand up to the bullies.
Sure.
And I do think that they do a service. I do think that people who invent should be rewarded. There's an incentive. That's the way the patent system was set up. And so they should get their due for what they did. On the other hand, there are some companies that have made a business out of leveraging that process. And unfortunately, litigation can be expensive.
Yes.
And some companies, particularly the bigger manufacturing companies, face what we sometimes call nuisance suits. These are suits where maybe the case is not that strong, maybe it's not really a situation where the company is using the patented technology, but it's close enough that it's difficult to make that litigation go away, it's disputable. And then the threat of litigation and the cost of litigation becomes the major negotiating concern as to whether to pay these people off.
I see.
And so both of those are going on in the market. Some of them are very legitimate in helping people. Some of them, I think, are just creating nuisance suits for the sake of getting something when they really haven't done anything valuable for society.
Yeah, to deserve the incentive that the patent system
I think there are both
offers.
kinds out there. I think there are both kinds out there.
So when you're dealing with the legitimate kinds of patent owners and those who are assisting the patent owners, what can lawyers do to facilitate bringing that property to the market? How can we facilitate a good outcome for essentially the economy as well as the inventor?
Yes, there's a question as to where the line is between being a lawyer and being a consultant. So because IP law has this sort of dual role of being property and being law, it has a business aspect to it and has a legal aspect to it, some intellectual property lawyers, and I consider myself to be one of them, will also have experience in the business side of IP.
Right.
And I think that's good. I think that's good because in general, like I say, I think law serves a purpose, and if the purpose happens to be an economic purpose, as it often is in this case, then the business concerns can guide the choice of legal decisions. So I think lawyers can do two things. They can be good lawyers. They can help. They can do their legal job. They can help inventors get patents or secure the rights. They can do copyrights, filing copyright registrations, filing trademark registrations, those kinds of things, advising on how to protect trade secrets. There are procedures that companies should follow to protect their trade secret rights. And so behaving correctly under the law is advice we can give. Going out and helping them in the various forums are things we can do as lawyers. We can go to court to enforce, we can go to court to defend, we can go to the patent office to help them get their patents from the patent office. We can write letters back and forth to people who may have disputes. Those are all the traditional legal things. But I think we can also advise them on whether it's making sense, on how to use it. That question, when, for example, to enforce a patent, well, there's a legal aspect to that. Do you have a case? Do you meet the legal requirements for bringing a suit? But there's another side to that. Is it worthwhile? It's a return on capital. If you're going to spend so much money on this lawsuit, would you be better off spending that money on 3 more employees?
Right.
I don't think that's necessarily the lawyer's job to make that decision, but I think the lawyer can help bring those considerations on the table and help the decision maker factor those into the decision.
So to me it sounds as if the lawyer is adding value in that situation if he brings that component to the table and says, I'm not just going to perform my traditional role. I'm going to help be a strategist to get you from point A to point B. Because essentially what we learn about intellectual property is the benefit is ultimately for the public, and then the secondary beneficiaries are for the inventor or the creator. And then downstream for the licensee or other sub-licensees who may get access to the intellectual property. So those to me are sort of the three tiers of beneficiaries. And what we're doing as lawyers is actually helping to strategize how to optimize the benefits for those stakeholders.
I actually think the value added by an IP lawyer / consultant could be higher in the consulting role than actually in the legal services role.
Tell me about that.
Well, let's suppose a company has intellectual property, they think perhaps there's a infringement. The legal advice could be sue the other guy.
Right.
The business advice may be save your money. The advice to maybe avoid a cost or to settle a case if you're on the defense side, that value in terms of bottom line, in terms of the net value of the company before and after the decision, may be more than the cost of the legal services to get a patent or to go to court. So it's an interesting aspect of the relationship.
Well,
it's fun, actually.
Yeah, you talking about a consultative role as opposed to a legal representation role makes me think that the intellectual property field is even more open to people who don't have specific science backgrounds. This seems to open the doors up to many more people who might look at this as a career path.
There are people who specialize in intellectual property monetization, specialize in licensing. Not many people are good at it. It's a difficult area because it brings in some different areas of expertise, and not many people develop all those different areas. To be a businessman or a businesswoman means to know your business, you know your competitors, you know your cost structure, you know kind of where the markets are going. To be a lawyer means to know the law, and to be an intellectual property lawyer can, particularly if it's technology related, can mean to know the technology. So you've got these three areas: law, business, and technology. And the decisions pull all three of them. And what I find more often is, and I work with a lot of clients this way, it is almost a committee decision. We always deride committee decisions. Too many people, too many cooks spoil the broth. But I will often get together someone from marketing in my client's organization as part of the decision whether to file a patent application. Because I want the client to think, if I get this patent, will it help my business? Sometimes there's a bias towards getting patents. I'm going to get patents. I'm going to get as many as I can, hoping that one of them will prove valuable. But what's the role? Maybe a more specific example, if you have a product improvement, is that improvement something that a member of the buying public will choose on? So if your product can do some feature, will that make more people want to buy your product? If the answer is no, what's the value of that feature?
Yeah. And sometimes obtaining patent protection can also be for public or social benefits. I know a lot of companies gain patent protection just to give the patent technology away. I was just listening to a report on NPR. I hope I can say NPR on ThinkTech Talks. The report was about the owner of Tesla saying, we're going to give this patent technology away.
Yeah.
Right?
It does happen, yeah.
It does happen.
Right.
And I tend to look at the good in everyone. So when I heard that, I thought that it was a sincere gesture to try to move along technology for electric vehicles that are stylish and really good looking. And that's what the owner was trying to promote by giving the substance of the patent to competitors to see if they could come up with something better.
Yeah.
So have you found that in your practice?
I have found some really interesting uses. I did some work for a group called the Appeal of the Nobel Laureate Foundation. Long name, but they represent living Nobel Prize winners in peace processes. And they were involved in the Sri Lanka conflict, where there had been an attempt to get the two parties to meet. One side decided to ambush the other side and just kill everyone. So, I mean, I say that somewhat cavalierly, but it's a serious situation. To try to get over that, they tried to do a kind of an online negotiation. They wanted to get all the stakeholders to have computers and set up a common area where they could exchange communications, hold meetings, and have private areas where different stakeholders who maybe were on one side or the other could all get together. That software was protected by copyright, and we ran into some interesting issues there, but they wanted to give that away so that they could facilitate discussions in the peace process. So yeah, you do find some really interesting situations where that comes up.
And I'm not saying that I hope that that's the paradigm that everyone will jump on board with, because obviously there's value in being proprietary. But there is also this social benefit to intellectual property that I think many people don't recognize. They look at it as a very static kind of a deal or a transaction. They look at it as very just antiseptic, if you will. But it's not. It really, intellectual property, as you mentioned earlier, affects our global relationships.
Oh, absolutely. Another area where it comes up is what are called the patent pools. This is not necessarily a free giveaway, but it has to do with standards, the VCR standards, the DVD standards, wherever you get an industry with a technology where many different companies want to contribute to that market. You don't want to have the industry broken up with each little patent group trying to sue each other to get control. It's very disruptive, and so oftentimes what happens is when the standards are set, all the participants in setting that standards agree that they will contribute their patents to a common pool or somehow or otherwise make the licenses available on a non-discriminatory basis, so that there's no fighting in that area that could prevent the full distribution of that technology.
Yeah, that you're referring to the FRAND standard, right? And it means something, right? But I always call it the friendly and non-discriminatory standard.
Friendly and non-discriminatory standard.
But that's not it. But yeah, that's exactly right. The patent pools also pull in this direction of a social benefit being achieved by use of intellectual property. Well, it's excellent discussion we're having with Stuart Huang, our guest here, talking about intellectual property in the islands. We'll be back in a moment.
I'm Jay Fidel. That's Sharon Moriwaki of the Hawaii Energy Policy Forum. And every Wednesday we have Hawaii, the State of Clean Energy. We've been doing it for some time now, and we have some fantastic guests on there, unbelievable guests who give us insight into what is going on in a very complex, sometimes very confusing, sometimes very disappointing area of progress in the state. So we love doing this. We love meeting them. We love talking to them. We love having their ideas out on the table. So maybe, just maybe, we can all make some sense of what's going on. Sharon, what do you think?
I think it's absolutely correct. We enjoy ourselves meeting with all these people and hearing about the energy and the state of clean energy, and hopefully we advance clean energy for the state. So it's terrific. Join us.
Okay, it's every Wednesday. Okay, Wednesday is Energy Day. Every Wednesday, 4 to 5 p.m. Hawaii, the State of Clean Energy, here on ThinkTech Hawaii. We'll see you there.
Welcome back. I'm Danielle Conway, and you're watching Life in the Law in the ThinkTech Talk series. My guest is Stuart Huang, and we're talking about intellectual property in the islands. Now, our discussion has actually really been global, but I do want to bring it home. The reason why Stuart Huang is a guest today is because he's so wonderfully volunteered to teach the Intellectual Property Survey course at the William S. Richardson School of Law this coming fall. And I'm excited, but the students are also excited because it's an opportunity for them to actually take advantage of someone who has actually been in a patent practice, which I have not, and also been a partner at a major law firm in Washington, D.C., another thing I have not done.
Well, we'll see what they say after the class.
But I'm really happy that you're doing that because,
I'm delighted to help.
Yeah, it is a big help. But more than a big help, it gives a very different perspective than I bring to the table. And so that perspective is one of what are the things that you can do both professionally, socially, economically, and for the public. What can you do with intellectual property? So I'm really excited that you're going to be doing that here in Hawaii. And as you know, we have founders or potential founders here who are very interested in their own startup businesses, social entrepreneurism. So they really want to get a piece of what you know. And so how has it been transitioning to being back in Hawaii? You were born here.
I was not born here, but I've had family here.
You
I've been
have
coming
family
here
here,
for
okay.
20 years plus.
Okay.
Several weddings here, one funeral here.
So you've got connection.
I do. I've been here on and off for quite a while.
Has it been a big change for you, transforming to life in Hawaii after being in so many places?
Not really. I ended up sort of settling in because I was passing through here so much. It seemed to, if you look at the random walk, if you could take the map and follow me around, somehow it just kept passing through Hawaii over and over and over again. So I decided just to make my base here. I'll still probably travel.
Okay.
I have a hat that I've gotten to most of the continents. I still have to get it to Australia and Antarctica.
You know, I think about Antarctica a little bit. You know, they had that ship that got stuck just a couple of months ago,
Right.
and that
right.
stopped me from thinking about it. But you're not deterred.
No, I would actually like to find a way to get there, not just as a tourist, but to have some sort of a project there. And I've actually dealt with some people who have gone to Antarctica. One was a
Okay.
marine scientist doing some studies
Okay.
underneath one of the ice shelves, and the other was an astronomer who had a astronomical instrument down at one of the Antarctic bases that broke down, and he had to fly down and fix it. So
Yeah.
I volunteered, but I don't have enough knowledge on telescopes to go and fix that thing.
Well, we're going to introduce you to some people. I think I have some people for you to meet.
Wonderful. Any place I haven't been before.
So you were also teaching an ethics course.
I did.
At the College of Engineering?
Yes, yes.
What was that about?
It was, okay, so to get an engineering degree, one of the requirements for the students is to take a ethics and professional responsibility class.
Okay.
I'm qualified to teach both in the engineering school and in the law school because I have graduate degrees in both. And I wanted to teach. It's been something I've wanted to do for quite some time. We worked it out, and it seemed like ethics was a good first shot for me. So I taught the professional responsibility class last fall.
And how did that go?
Oh, it was great. It was wonderful. Really interesting. Talking with the students about ethics, I tried to find ways to trick them into, I don't know, breaching contracts, lying.
They weren't falling for it.
Oh, some of them fell for it so easily. But that was the point. That was the point, because in real life, no one comes up to you and says, here's an ethics situation, would you please apply the ethics analysis? In real life, you're just going about your business, and little data points kind of start to create an image in the fog until you put the pieces together and you say, oh, I have an ethical situation. So actually one of the things I tried to get them to do was to recognize when they had an ethical decision that they had to think about. So many people just kind of stumble into them and they have a gut reaction, this feels right, this doesn't feel right. But yeah, it was a lot of fun.
Well, and there are neat intersections between the College of Engineering and the law school, particularly at the nexus of intellectual property, but also, I like to say, at the nexus of government contracts,
Yes,
right? Because engineers oftentimes do work for governments,
Yes.
and part of their responsibility is to do work at a benchmark level. And so that's where your ethics come in.
Yes, it does. Engineering students tend not to take a lot of arts classes. They don't take a lot of history, they don't take a lot of political science, they don't take a lot of English. And so they don't get the same opportunity to think through these societal issues the way other disciplines might let them do it. So for many of them, this was hard, actually. Some of them fell into it very easily. Some of them really struggled with how to articulate why something is right or something is wrong. And I think if there's anything I tried to do was to get them to develop their own sense, not intuitive, but so they could actually spell out why they think something is right or something is wrong.
Right. Well, we're hoping that a lot of what you dealt with in the ethical realm will transition over to the intellectual property law course, because we have so many societal issues that are impacted by the proprietary nature of intellectual property or the misuse of intellectual property. And while your background is patent law, you are versed in the other areas, trademarks and copyright. And so I think one of the bigger issues that you'll probably see at the law school, because students are interested in it, is the protection of indigenous resources and indigenous assets. And if you're going to be here in Hawaii, you're going to have to jump into it.
And that's one of the wonderful things is always to add on knowledge in the, I call it the penumbra, in that glowing region around the center of what you do.
Exactly.
So being an IP person in a general practice firm, I got called in on employment matters, I got called in on mergers and acquisitions to do due diligence, I got called in on government contracts matters, I got called in on export control matters. So it's really part of what makes, I think, the practice interesting is when you can grow and add and see how all these things fit together.
That's right. And
sometimes they don't fit
sometimes
together.
they don't fit together, but you still have to address them anyway.
Yeah.
So what would you like to see the attorneys that practice intellectual property here in Hawaii, would you like to see them tackle, say, in the next couple of years? Should we be tackling the way we charge client fees? Should we be tackling the way that we communicate the existence of intellectual property opportunities here in Hawaii? Because when I first got here in 2000, there was this underlying narrative, there's no IP in Hawaii.
Yeah, that's not true.
Okay, good.
It's not true.
I kept saying, no, that's not true.
Yeah.
Not to just justify my existence.
No, it's here. It's just under-recognized and underutilized.
Yeah.
I think it would be to get more involved in community awareness and to some extent get a little involved in state policy. So for example, when I came through here 4 or 5 years ago, there was a tax provision called Act 221
Yes.
that facilitated investment in technology development. That did a lot to bring innovativeness to the forefront, to say innovation can be a viable business here in Hawaii. But it's a fledgling community. It's hard. Like all startups are hard, no matter where.
Right.
And so if they could, lawyers have the unique ability, I think, to deal with law, and that includes dealing with the legislative process, dealing with policy. And I think if they could help grow the entrepreneurial spirit and support those kinds of things, it's hard because it takes away from their primary responsibilities. But I think that's an area where I think they would be in a unique position to try to help out.
Yeah, I agree with you. I particularly am interested in intellectual property as it relates to government contracts and the development of innovation, because let the government underwrite the innovation and deal transactionally with a revenue stream that'll get you capable of further innovation.
It's hugely important. A lot of research is done with government money, either through university or through private grant writing.
Right.
I know several organizations here that are developing products and they're not, strictly speaking, part of the research operation of the university, but they're still working through NIH, working through various government agencies for funding. All that money comes with IP streams attached, and they have to understand what they're doing.
And that's why you are so valuable to us as a visiting professor of law, because you actually have that expertise and you've dealt with those kinds of clients.
Yeah, I've been down in some of that for matters. I did a lot of work for defense contractors, and one of the maybe 3 big ones I did quite a lot for, including litigation, including fighting over data rights and all that kind of stuff.
Right.
And it's surprising how that knowledge is not as generally available as you might think.
Yeah, we were having a discussion about that. I was saying I'm naive, but I thought everybody knew this.
Actually, the people, other than lawyers who specialize in government contracts, the ones who understand it are not lawyers. They're contracting
Professionals.
professionals.
Yeah,
They're in the Raytheon contracts department, because
Right.
they see the actual clauses in the contracts day in and day out. They
Right.
know that that number refers to this clause that means this, and the contract itself sometimes only refers to a number. You get
That's
this,
right.
you give them a contract, it's got this 3 pages to the back with just a table
the-
of
yeah.
numbers, and the numbers each correspond to some clause in some book somewhere.
Right.
And if you don't know that 252.227-7013 is an IP clause,
Yeah. Well,
no one's going to go look
you
them all
don't.
up. It would
You
take
don't know
forever.
what you've agreed
don't know what
to
you've agreed
or
to.
what you've given away.
and that's happened a lot.
And it does happen a lot, yeah. And I think also at the state level, I'd love for us to take advantage of your suggestion to get involved in state policy, because I also notice at the state, there's not a significant level of appreciation about intellectual property development doing state government work, and how the creation of dual-use technology will actually help the state further innovation.
I think they actually do understand it at one level, but they just view it narrowly. Hawaii as a tourist destination is a brand that is world class. Everyone in the world wants to take a vacation in Hawaii.
Exactly.
That brand, that's intellectual property. What I think the state does not have an equal degree of awareness of is not just trademark branding, but also the other intellectual property rights. That there is
Right.
technology going on here, that this can be a place where the tech industry can contribute to our standard of living.
And we have to help make that work.
I think so.
Yeah.
I was told that traditionally the economy had 3 major legs. There was tourism, agriculture, and the military. Tourism, depending on how you ask, it has its ups and downs,
Right.
but it has not been the growth engine over the last decade.
Right.
Agriculture has not been a growth engine. The military, government budgets, all government budgets are not probably going to grow dramatically,
Yeah.
although Hawaii may benefit a little bit with consolidation. So if you want to have economic growth, if it's not going to come from one of the 3 traditional sources, what are the other alternatives?
will
And I
it come
do see
from?
people developing biotechnology. I see people developing electronic technology. I see people developing an area where I think we have the potential actually to be a national leader is renewable energy technology.
That's been the overarching theme, renewable energy. Can I get you to come back and talk with us about renewable energy?
I'd love to. I'd love to.
Fantastic. We are at the end of our hour, unfortunately. I've been talking with Stuart Huang, and you've been watching Life and the Law in the ThinkTech Talk series. We're going to ask Stuart back to talk about more issues involving innovation and intellectual property here in the islands. Thank you for watching.